This is an interview with District Judge Larry Burns, and we'll just start out, Judge Burns, with asking you a few background questions. What was it that made you become a lawyer in the first place?
I think around 11th or 12th grade, I started to concentrate on what I might do for a living.
Wow.
My dad had been a police officer in Pasadena, and he was not a dumb guy, but he wasn't an educated guy. He'd been pulled out of school in the 7th grade, and in those days you didn't need a high school diploma even to become a police officer. So he eventually went back and became a police officer, but he always had respect for educated people, and particularly the prosecutors that he'd bring the cases to. And I can remember several times as a kid he'd bring me down and introduce me to these prosecutors with whom he was so enamored. And memories like that, stick when you're a kid and you're thinking about what you want to do and pleasing your folks and having a good life. So I think that was my initial orientation toward the law.
And then you had your father as an influence, and what else? Were there any other influences that made you eventually go to law school?
Well, eventually, I majored in speech and English in college, and in those days, speech wasn't what it is today, communication theory and internet stuff. It was getting up and making speeches and being given 5 minutes in a topic and embarrassing yourself a lot of times, but eventually developing the confidence that you could speak in front of any group. So I have to say I had a major professor in college that taught speech, and he encouraged me to go into a profession where I could use that skill. And I wanted to be a jury trial lawyer. I wanted to do jury trials, and so I thought that set of skills lent itself particularly to that aspect of the law.
So you really learned to talk on your feet.
I did, yeah. New lawyers, as you know, have butterflies the first time they stand in front of a jury. Well, I didn't know much law, but I was pretty bulletproof about standing in front of a group of people and rattling on for a while.
Yeah. And so then what was your practice to begin with?
My first job out of law school was with the DA's office in San Diego, and I worked there for about 6 years. And it was, for young guys, it was a great place to start because it was high-volume trial work. In January of 1981, 1 month, I tried 10 cases to jury verdict in a month. I was out of court 1/2 day. Now, these were all, misdemeanor drunk drivings, thefts, but it was great experience. At one point, I was presenting evidence to one jury, and I had 2 juries out deliberating. So it was sort of ordeal by fire.
Yes.
And I probably, in the 6 years I was there, I probably tried 100 jury trials. So I felt like, I was ready to move up and do more complex trial work, not just thieves and drunks and prostitutes and all.
Right. So in my experience, you get to know one judge particularly. Were you always in one courtroom when you were doing that?
No, as a matter of fact, we moved around. We would be assigned for a while to a court, but we moved around to different courts, and we had a pretty small bench. At one point I was sent up to the North County office in San Diego, and I got to know all of the judges and their likes and dislikes, and whether I had to stand next to the lectern or I had a little latitude to move closer to the jury box.
And how many judges were there that you rotated amongst?
Oh, I think in those days probably 8 up there.
Okay.
It was a small bench. It was a branch office of the main Superior Court in San Diego.
So you got to know every judge.
Got to know everybody and began to kind of assess things that I thought were good traits in judges, good practices, and then things that were maybe not so good.
Yeah.
Thinking that if I ever become a judge, there's some things I'm going to emulate, and then there's some things I'm not going to do.
So you had that in your mind already.
I did.
Yeah.
I did.
But then you went on in your career before you became a judge.
I did. I became, after 6 years at the DA's office, I got an opportunity to go to the U.S. Attorney's office. And in those days, I don't know if it's still true, reputation in the legal community was that was a little bit more of a prestigious place to be. You did more complex cases. At the time, my wife was pregnant with our first child, and they offered me a $10,000 raise. So I jumped and began a career as a federal prosecutor. I stayed for 12 years and prosecuted a lot of cases, tried a lot of cases. This was a time when Congress was starting to criminalize a lot of offenses that had traditionally been state offenses. And a lot of my colleagues in the U.S. Attorney's Office did not have street crime experience. They'd come in from law firms or they'd come out of law school.
Yeah.
And I had tried a lot of the kinds of cases that were the newfangled federal crimes, carjacking, for example. And so they were funneling me those cases, and I was doing exactly what I wanted to do, which was trying a ton of cases again. And this time in a much more majestic setting. The federal courts were much bigger, resources were much greater, and you were working with very professional law enforcement agencies, the FBI, DEA, Customs, and all.
So and you're trying a different kind of...
I was, in a sense. I mean, at bottom, these were the same kinds of cases. I was doing a lot of firearm cases. They cracked down on the firearms in the 80s, made it an enhanced penalty if you were a multi-time convicted felon found with a firearm, and we were trying to emphasize that. I think that was the emphasis of the administration at the time. So I probably tried 25 of those cases. They're pretty easy cases to try. And then I tried a number of murders. You don't usually see a murder case in federal court, but in our district in San Diego, of course, we have Camp Pendleton, and so crimes against non-military on the base are prosecuted in federal court. So I had cases where people had killed military dependents, or they attempted to kill military dependents on the base, and I tried a bunch of those. And in a number of cases, I went back to state court. I went back about 8 times and tried cases in state court, including 2 murder cases. We had developed those cases in the course of grand jury investigation into a federal offense, and the DA knew me, and my boss said, yeah, if you want to go back and try that as a special deputy DA, you can. So I went back to where I had started and tried those cases, even though I was a federal prosecutor at the time.
And you did that because they came out of the grand jury.
That's right, yeah, because I knew the cases. A couple of them were, what we call cold case murders now. They hadn't been solved for a long time, and one thing led to another, and we developed enough evidence to prosecute these cases years after the murders had been committed. And those cases always involve intense investigations and close relations with the few witnesses that you have, and so it made sense to have somebody that was familiar with that handle the case. But and I enjoyed doing that. I enjoyed going back and having a respite from my usual job. And I was over, in one case, I was over about 8 weeks in state court, another about 6 weeks. But it was, the FBI agent would pick me up at my house every day, and we'd drive up to the Vista Court together or go over to the Superior Court in San Diego together. So it was good work. I mean, if you like trial work, then this was the place to be.
Yeah. So how did your appointment to the bench go?
Well, around 1997, I got serious about doing something different. Wasn't that I was bored with it. I think I could still be doing it to this day, although I think trial work's really more of a young man's...
It grinds on you.
It does. And you, as you probably know, you carry the burden of it. I mean, particularly in these cases where there were victims of crime, a lot of times the prosecutor becomes the champion of the victim or the victim's family, as the case may be. And that weighs on you. I mean, they want a good result, and
feel responsible.
They're looking for you, and you internalize that. And so that was the pressure that I was feeling. I wasn't feeling pressure about actually going in and trying the cases, and probably was overly confident on most of the cases. But it's still in the back of my mind was the prospect that people are looking for a result here, a good result, and first and foremost that obligation is with me. And then I thought I'd accomplished what I'd wanted to accomplish as a lawyer. I wanted to master the trial skills. I had become a fellow in the American College of Trial Lawyers, which for me was a high point in my career, and done just about everything I'd wanted to do. And so I turned my attention toward, another goal, which was someday being on the bench. and applied for the position, went through the merit selection committee, and was selected. I was as surprised as anyone as the word was out that there was a favored candidate who'd been recruited and all. We were all interviewed, and then of course the district court deliberates on who they're going to pick, and I was so sure that they were going to pick this rumored favored candidate that I checked out for a long lunch. I called one of my buddies and said, I put my best effort in, but I'm not going to get it this time. And I didn't come back to the office until about 3:30. We had a couple of beers together, and of course I had the phone call waiting for me, and I thought, I got to call now and get the bad news.
Yeah.
And he could have knocked me over with a feather when our chief judge said, "No, you were the one that was selected this time." I said, really, I'm very, very surprised. I didn't expect this outcome at all. But I was glad to have it. I think that experience as a magistrate judge really helped prepare me for being on the district court. The gap in my resume, of course, was I'd not been in civil practice. I had been a director at a bank, a local bank, and the only lawyer on the board of directors. And as such, I didn't act as in-house counsel per se, but I handled all of our legal matters by hiring outside counsel, consulting with them.
Yeah.
So I had an idea of employment law, government regulations, and the types of civil disputes that businesses often find themselves in. But I hadn't practiced. I hadn't done discovery work. I hadn't done the grind, and hadn't filed motions for summary judgment or motions to dismiss and all. So the 6 years I did as a magistrate really helped prepare me for that, because the task of the magistrate judges, at least in our district, was primarily civil. I came in at a time when we had a lot of cases. We had a crush of criminal cases, of course, and the civil cases were back burner because the criminal cases got priority. And our district judges emphasized to the magistrates, we really need you to roll up your sleeves, find out what these cases are about, get the parties focused on the important issues, and settle the cases. And so I developed some settlement skills during that period of time. I was, and I took it on as I did trial work. It was kind of a competitive enterprise. I didn't want to fail at that. So I was a prolific settler of cases for a while.
You're a good arm twister.
Yeah, pretty much.
Who was your chief judge when you got appointed?
Judge Judy Keep.
Yeah.
Yeah, she was just magnificent.
She's a nice lady.
Oh, she was. We had very good judges when I was there trying cases, but I have to say, even among all the very good judges, I always preferred to be in front of her. Mm-hmm. She was smart. She was engaged. She'd call it right down the middle, and it didn't matter whether you were on the prosecution or defense side, or in civil cases, plaintiff or defendant. She was very, very objective, and you always knew that she'd read everything that had been filed. In some courts, I have to tell you, I've had the experience of going in and having the perception that the papers weren't even read, that somebody was just flying by the seat of his or her pants. But it was never that way with Judge Keep. Yeah. She was just wonderful.
And how did your appointment to the district court go?
Well, we again, spade of good fortune. I'm not going to tell you it was because I was very qualified or well known or any of that stuff. It's sort of like, I tell people, it's sort of like the pencils in the pencil factory. When you're over the hole at the right time, you fall through, and that was my experience. Congress approved 5 new district judgeships in San Diego, and so we had 5 appointments in very short order. Which of course made it easier to compete for one of the appointments. And I had a good reputation as a magistrate judge in settling cases, and I'd gotten some awards from the bar for being a good arm twister, as you said. So I had that component that had been missing in '97. I had that covered, and the criminal stuff was second nature to me. So I felt I was qualified for the job, but that's only half of it. As you probably know, it's not completely a meritocracy. You got to know people. We had a merit selection committee of sorts for the district court. The 2 senators who were not of the same party as the president at the time negotiated with the White House, and the result was we had a committee of 6 people. The senators picked 3, and the White House picked 3. And the agreement, as I understood it, between the members of this committee was that if a person could get all 6 votes, that the senators would back any nomination that the White House made of a person that made it through that process. So that's how I got to the district court.
You didn't experience any of that long delay or pushback that some of the other judges later experienced?
No. I mean, look, when you're in the chute, you're in the box ready to go. You're always anxious about how long it's going to take, and it seemed like it took forever, even though it only took about 6 months.
Is that right?
Yeah.
Wow.
I think we got nominated in May, and I was confirmed in September. The process, of course, began before that, with the application and all. But I think from nomination to confirmation, it wasn't very long.
You want to talk about any of the cases you want? I mean, this is your interview, and you can talk about anything you want. But I know there's some notable cases that you've tried, and you may want to discuss.
Well, that's some of that is pretty dated. As far as trying cases as a lawyer, you're talking about trying cases as a trial judge?
As a judge.
Oh, okay.
I mean, there was a Gifford-Slogner case, and
yeah, there was. Maybe the first case that had any great public attention came to me after only about a year and a half on the bench. We had a crooked congressman in San Diego, and this fellow had been really revered, not just locally but nationally. He'd been a Vietnam War ace, one of two in the Vietnam War, which meant you'd shot down 5 or more enemy planes. He had ejected over North Vietnam and wrecked his knee and had to be rescued, and then he got back in a plane and flew another 180 combat missions, and he kind of rested on that laurel to get elected. And he fit the culture of the community at the time. He said things that everybody agreed with, and a very popular guy, and many terms in Congress, had worked his way up to the number 4 position on the House Appropriations Committee, which in my view is probably the most important committee in Congress. They write the checks and they authorize the spending. And seemingly, he had everything going for him. He had a good reputation. He was going to be elected any time he ran, but he started taking bribe money, and he started taking other forms of bribes, compensation from contractors trying to do business with the government, and just corrupted himself. And it eventually came to the attention of the FBI, and after a long investigation, he was indicted, and he showed up in front of the federal court and held a big news conference and shook his fist and said, "This is outrageous, and the people responsible for this are going to pay a price," and so on. And as the case developed, the evidence was just overwhelming against him, and it resulted in his guilty plea. And so I had the case. I had the case for if it had gone to trial, and I ended up sentencing him. And by that time, with all of the information that had come out about what he'd done, he'd gone from a figure of adulation to an absolute pariah in the community. I mean, people wanted 3 days in the electric chair, for him. It was that bad. The sentiment was running that high. His sentencing, only a couple of people showed up in his behalf. One of his fellow congressmen, who I gave credit to because it was not a popular thing to be a friend of his at that point, but this guy remained a loyal friend, and he showed up. And then his tail gunner from Vietnam days showed up. But other than that, it was filled with reporters and antagonists and people that, as I said, wanted to see him get the maximum sentence. So that was a difficult case. On the one hand, he'd done very terrible things. Things that kind of cut at the foundation of our democracy, and we live in cynical times, as you know, and all he did was increase the level of cynicism toward our system in Congress and congressmen. On the other hand, here's a guy with an undisputed record as a war hero. I remembered when I sentenced him that in 1972, when he was over there flying these combat missions, I was sweating it because I had a draft lottery number. Yeah. And I thought to myself, I could have been sloshing around over there in the rice paddies in Vietnam. I didn't have to go. I was fortunate for that, but I appreciated guys that did go, and particularly, guys that understood the sense of mission as he did. He'd really come 180 degrees from what he did for his country in those days versus his conduct as a congressman. So it's a tough case. I didn't give him the maximum sentence that everyone was clamoring for. I think I cut a year and a half off owing to his military service.
Yeah.
But it was an interesting case. I ended up later in about a 3-week trial with a businessman that bribed him. That guy went to trial, and that resulted in a trip to the Ninth Circuit a couple of times. So over a long, extended trial, I had the celebrity lawyer Mark Garagos defending that guy, and he's a handful. If you've ever encountered him,
I know Mark quite well, actually.
Good lawyer, but really a handful, you know, and a very busy guy. Had a lot on his plate, so I had to keep him corralled down in San Diego for a period of time, and that was one of the toughest jobs. But.
So I remember the Cunningham case, and the press at the beginning, everyone was shocked and in disbelief, I think, as I remember it. And then as it progressed, as you said, it turned 180 degrees.
It did, yeah.
How does that affect you?
Well,
if at all.
I don't think it had any effect on me. I mean, I watched with interest. The case had been assigned to me. I anticipated we were going to have a trial. Of course, you know, my job is, as I see it, as a trial judge, is to provide a level playing field. Mm-hmm. You know, mindful of the presumption of innocence, mindful that the burden is on the government, but nonetheless a level playing field, and then let the chips fall where they will. I going back to what I said earlier about the stress of being a trial lawyer, I have to tell you, I feel none of that now. Mm-hmm. I occasionally will have opinions about what the outcome should be, just like anybody else. You sit and listen, and you say, well, either it supports a verdict of guilty in a criminal case, or it doesn't, or it supports liability. But I don't have any heartburn over it, even if the jury goes the other way. I go home and have just as restful a night of sleep as I had the day before the verdict. So I wasn't stressed about that. I knew it had a lot of public attention, and I wanted to be precise. I wanted to be right. I wanted the court to be presented in the best possible way. Those were concerns of mine. But regarding the outcome or the challenge of handling a case like that, I wasn't very worried about that.
Yeah. You want to talk about any other case?
Well, the other case I had that I think had a great deal of public attention was a case against Jared Loughner. He was the Tucson shooter that killed 6 people, including Chief Judge John Roll down in Arizona. I was acquainted with Judge Roll. I admired him a great deal. I think everybody did. I think anybody who had come to these conferences at some point or another had the experience of Judge Roll extending his hand and saying, "Hi, I'm John Roll. I don't think we've met." Mm-hmm. He was just a wonderful man and a great judge. And of course, he was shot and killed that day. And then Congresswoman Gabby Giffords was shot, miraculously survived. Yeah. Took a bullet right in the forehead, and suffered disabling, permanent injuries from that. But this fellow killed 6 and wounded another 13 people in Tucson that day. And the Arizona judges decided fairly quickly that they did not want to handle this case, one of their colleagues being a victim, and so they needed a judge from out of the circuit to handle the matter. Judge Kaczynski appointed me. I read afterwards that he said he took into consideration that I had a lot of trial experience and that I'd actually handled a previous federal death penalty case. I had a case against the Tijuana Cartel, the Arellano Felix case, and I sentenced most of the people involved with that. And at its inception, the government was asking for the death penalty in that case. It ended up in a plea agreement where the main defendants got life without parole. But I was familiar with the federal death penalty statute and with the procedures, and I had handled special circumstances cases as a lawyer. And I think that may have played a part in the decision to assign me. But I went to Tucson and I handled that case. And you may recall that the defendant was a schizophrenic at the time and not competent even to stand trial. We had psychiatrists look at him and they said, he doesn't know what's going on here. I mean, he hasn't seen the ball since the kickoff. And so a great deal of the litigation in that case early on had to do with whether the government could medicate him and restore him to competency so that he could be tried. And the defense objective was to prevent that from happening. As long as he remained incompetent, he could not be tried, and he wouldn't face any prospect of being put to death. And so we went back and forth, numerous hearings on his competency, on whether his competency could be restored, on whether the government could stick a needle in him with drugs that would restore his competency. Eventually, he began to harm himself in prison. And the warden of the prison where he was being held was concerned that he was going to kill himself. And so the prison went in and involuntarily medicated him. And Jared Loughner's lawyers ran back to court and said, wait, they can't do this. This is like an end run around all of his due process rights and the right to a hearing on medication and side effects. And I said, look, I had nothing to do with this. I didn't order it. The government didn't request it to get him competent. We're talking about two different objectives here. They're trying to keep this fellow alive, keep him from harming himself. But that was an issue that went up to the Ninth Circuit twice. First time, the Ninth Circuit ordered the prison warden to stop giving medication. And Loughner got progressively worse. It got to the point that they thought, he was near death. And so, notwithstanding that prohibition issued by the Ninth Circuit, the warden ordered remedication. And when they came back the second time, the circumstances had changed. I mean, his condition was measurably worse. And another panel looked at it and said, "No, we think the warden has this authority, and we think it was properly exercised here, given what's undisputed about this fellow's medical condition and his self-destructive behavior." And so that kind of coincidentally ended up resolving the case, because as soon as they gave him the medication that prevented him from harming himself, he regained his competency. And by then, enough time had passed that the sting of this in the community wasn't being felt as it was within the weeks and months immediately afterwards, and they were able to work out a deal where they took the death penalty off the table, and I sentenced him to, I think, 6 life terms. So he'll be in prison the rest of his life, which he deserved.
This medication issue is interesting. You never really hear about that because it's not, I guess, sexy. You don't hear about that in the news, but that must have consumed quite a bit of your time.
It did. There have been several Supreme Court pronouncements on it, and the Ninth Circuit had spoken on it many times. If you canvass the cases, almost routinely they come down against the government sticking a needle into somebody, and there's a very strict protocol that a court has to consider and go through, including side effects, if there's any other measures, the seriousness of the crime, and you're prone as a trial judge to be second guessed on that. And I was aware of that. I mean, I tried to make as thorough and detailed findings as I could. As I said, it never got to the point where I authorized him to be medicated, but the argument was, if the government can't do it, if the prosecutors can't do it, then the warden, can't backdoor this and become, cat's paw for them. But there was no evidence that there was any collusion between the warden and the prosecutors. The warden acted independently in the best interest of the defendant at the time.
You must be one of the few experts on this.
Well, I don't know about expert. Judge Bybee wrote an opinion that was about 110 pages long. So, looking for experts, go to him. Yeah.
Okay. Do you want to talk at all about the Felix Cartel?
Well, they had plagued the southwestern border for 25 years. I was never in the narcotics unit when I was in the U.S. Attorney's Office, but I was well aware that the U.S. Attorney had indicted many of those cartel members, and I never thought much about the case. The investigation was going on when I got there, and it was still going on 12 years later when I left. And they got a lucky break at one point. They had a tipster in Mexico who said, "Look, the head guy in this cartel, Javier, Felix, one of the brothers, likes to go out deep sea fishing, and he'll leave off of Cabo on certain days, and he goes out past the international mark, and he's in international waters, And one thing led to another. They put a tracking device on the boat that he used and had some information, and they were laying in wait for him in a Coast Guard cutter out there when he came across. And so he and a bunch of his lieutenants were on the boat, all arrested. I remember the day they brought him to San Diego. The case hadn't been assigned to me yet. They closed down the main street in downtown Broadway, and they had a motorcade where they picked him up at the Coast Guard cutter and brought him up Broadway and took him to the federal jail, where he remained through the duration of the case. But he was a very high risk. They'd had experiences in the past with helicopters being used to free people from prisons, and it was forerunner to what's going on with this El Chapo fellow, and they had a lot of money and they had a lot of influence, and in Mexico they pretty much had their own way. So he came into court, and of course there was great security. There were magnetometers beyond the magnetometers to come into the court. They set him up in the corridor in front of my courtroom. And the marshals insisted that he be in body chains the whole time. And thought, we don't need to do that here. I mean, if they make it through magnetometers and a couple of phalanxes of guards, then we've got bigger problems than whether he's in chains or not. And I just didn't, in front of a jury, of course, the defendant can't appear in chains, but I just didn't want him in chains through the proceedings. And so I addressed him personally, and I said, look, I don't want you in chains, but you give me your word you'll be a gentleman, and then I'll treat you accordingly. And he gave me his word, and he kept it throughout. We never had a single problem. Marshals were fit to be tied because they wanted him in chains the whole time. So I had a couple of big knuckle dragging guys sitting behind him, most of the time in court. But but he wasn't chained, and he could write notes to his lawyer. But we eventually moved through that case. One of the big issues was whether he was actually in international waters. We had a boat captain who was not implicated in the drug ring, and he came up and said, look, we were still in Mexican waters, and I know these waters well. I've been fishing all my life. You can't see the buildings on the coast if you're out in international water, and I could clearly see the buildings. And what happened, according to him, was that the Coast Guard trained one of those big guns on him from the Coast Guard cutter and said, cut your engine. And then they deliberately waited for the boat to float out. So we had to resolve that dispute. In the end, it wouldn't have mattered much. There's a long line of cases starting in 1930s, Kerr-Frisbee rule that says it doesn't matter how the defendant gets before the court. I mean, if the authorities don't follow the right procedures, you can suppress evidence, but the manner in which the defendant gets in front of the court doesn't deprive the court of jurisdiction to handle the case. So it wouldn't have been a game changer anyway, even if I'd found that it wasn't in international waters. They have a suppression remedy, but they hadn't gained anything during the boat trip or the car trip to the MCC. But that was the big legal issue that went on for several days with an evidentiary hearing. And people estimating how far off the coast of Baja California. Yeah.
Well, we have a few more minutes. Do you want what else would you like to talk about?
Well, I'm very privileged, and I remain very grateful for having this job. I think it's a position where someone who's committed can do a lot of good, can do service to their community. I don't mean that as a platitudinous statement, because I can look back and see areas where the particular twist that I was able to bring to a case helped and resulted in a substantially just result for people, both civil and criminal cases. As I told you about my background, my dad's background, I think it's yet another of the tens of thousands of cases that are a testament to what a great country we live in, where in a single generation, somebody that's uneducated can have kids, and their kids can aspire to great things. And so I keep those things in mind all the time. They keep me grounded in the position. They along with my wife, of course, who says, I knew you before, so don't pull anything on me.
Keeps you real.
Yeah, keeps me real. So I'm very grateful. I'm still very much engaged. I deal with interesting issues and interesting people on a daily basis. one of our older judges, when I was appointed, said, first as a magistrate, he says, this is going to add 5 years to your life. And he was still on the court, still is now, but when I became a district judge, he said, this is going to add 10 years to your life. And going back to what I said earlier to you about the relief of the stress on my shoulders as the judge, I think he was onto something. I think he was right.
Well, you obviously are engaged with lawyers and your fellow judges. You come to conferences like this so that you get out and help us become educated.
Yeah, I think these are very valuable, and they allow interaction. Where otherwise, and we've gone through a situation in San Diego, for example. In federal court, we had a prosecution of 3 corrupt Superior Court judges. And there was a period of time in our legal community where the twain didn't meet. You kept lawyers at arm's distance because you didn't want any accusations of favoritism, and I think that hurt. I think that hurt the legal community. I really think it did. Judges were very reluctant to be seen in social settings, even with lawyers, for fear that a claim would be made. Now it's changed. It's let up a little bit, and I think that's good. And I think the interactions that we have here are good. You probably hear this from all the other judges, but we're sort of stratified and insular as judges. You're not in the legal community anymore. You're not chatting as much with people. You don't have your ear to the ground. And the value of conferences like this and interaction between the lawyers is you learn what's important to them. You learn things that maybe we're not doing exactly right or need to be changed or adjusted a little bit. I think that's very valuable. We have a very active Federal Bar Association, and so the conference is once a year, of course, but we have many opportunities for exchanges during that time. And our lawyers aren't reluctant at all to tell us that this order isn't working or we need some reform on this. And our judges, as a group, are very responsive, typically, to those claims from the lawyers.
We have a number of judges that sit on our Los Angeles Federal Bar, and I assume you sit on the board also of the San Diego Federal Bar.
I do, yeah. In fact, this year I'm a board member. It rotates, but that's good because we can help them a little bit with their planning of seminars and make people available and tell them issues where we think we've seen some deficiencies and we need work. We've in the last several years we've had either half-day or full-day trial sessions where we've taken some of the real leaders in the bar, and younger people have come for the day. We usually have a lunch, and we'll take a case from the beginning all the way to the end with different lawyers performing different tasks: cross-examination, direct examination, voir dire. And we've been very, very fortunate because we've gotten some of the top-flight lawyers to do these demonstrations and do this mock trial, and I think it's a very good experience for young lawyers to see the really gifted, experienced people practice their craft. I remember I had helped organize the last one that we did, and I remember watching the 2 closing arguments in the case, and I thought these were as good a closing arguments as I've ever seen. Real case, fake case, anything. I mean, these guys really put a lot of time into it, and they were both very powerful closing arguments, and I think they both educated and inspired these younger lawyers that are working on perfecting the craft. So,
well, we certainly appreciate the effort and the time that you all take, and Judge Byrne, thank you for sitting here with us for this time.
My great pleasure.
Thank you.
Uh-huh.